Morning and welcome everyone to our webinar, and a special welcome to those of you who are new. It's great to see so many of you join us today. And today's topic is looking at Labour's New Deal for Working People and specifically the pay implications of the Employment Rights Bill. And before we get going, I would like to introduce ourselves and just run through some housekeeping. So I'm Victoria Templeton, the HR Knowledge Manager here at HR Solutions. Having worked in the profession for over 25 years in various sectors and roles, my role at HR Solutions is focused on the HR-related knowledge that's then used for the delivery of our services. I'm joined by Sue Watson. Sue's our Operations Director and will also be supporting today's webinar. Sue's worked in the profession in senior capacities for many years and will share her insights on the topic from an employer's client's perspective. And because we've got so many of you here today, we've placed you all on mute, but as usual, we do like your involvement in the webinar. And we'll do that by inviting you to ask us questions. Thank you for those who have already submitted questions in advance as part of the registration process. We're going to aim to answer as many as we can, but given the time we have and what we're going to be going through, we may be limited to the number of questions we can get through, but be assured that we will follow up afterwards with a written FAQ as well. And on the screen now, you'll see an image of your GoToWebinar panel, and simply type in your question and then we'll aim, as I said, to read out and answer as many as we can at the end. We also like to make our webinars as engaging as possible, and we do this by using polls. So that not only do they help to steer the webinar, but it allows us all to share how the topic is being managed in our own workplaces. And actually it can be a really helpful way of sharing ideas of best practice and just seeing and sensing what other employers are thinking and feeling about the topic. So when you see this slide, we're going to run a poll. They are confidential. We only publish the results to the question. So we welcome as many of you today sharing your insights with us. So here's an outline of what we're going to cover. I'm first going to provide an introduction to the Employment Rights Bill, after which I'll focus on the pay implications of it. The bill sets out many reforms to employment rights, and it's believed to be the most significant development in employment law for decades. And it's wide-ranging. So we're going to spend some time towards the end on sharing our advice and thoughts on how businesses can start preparing for the changes ahead. And as I take you through the reforms, it will become clear how critical doing a HR risk audit will be, as well as an impact assessment. So I'm going to spend a little time exploring these two tools. And at the end, as I said, we're going to then hopefully take some of your questions live and give you our thoughts and input on those. So as I mentioned, the bill is far-reaching, and because we're limited with time and we're focusing from a pay point of view, I wanted to highlight now the fact that we're actually running a virtual employment law seminar next month where we're going to be looking more broadly at the bill and go into much more detail. So please do check out the QR code, sign up to that. It'd be great to have you with us. But in addition to the bill, we're going to be going through some other changes in legislation. So the forthcoming neonatal leave and pay, we have the usual April statutory rate changes, and we've got some guest speakers. So we'll be focusing on some health and safety legal updates as well as key tribunal rulings. So you will hear from our team on how these reforms are being managed in their client base. So that's next month, and we hope you can join us for that. Before I get going there, I'm just going to run a few quick polls at this stage. As I said, it helps to steer the webinar and just give us an insight into the makeup of everyone that's attending today. So the first question is around describing your business and whether that falls into the micro, small, medium or large category. So we'll keep that open for a few more seconds and let's see how it breaks down.
Okay, I'll close that poll and share the results with you.
Okay, so small to medium is predominantly the majority of you all today. That's brilliant. And then we have another poll, and it's really about how you manage HR in your own business. So who's responsible for it? Is it your business owner? Do you have an office manager? Perhaps you have in-house HR, whether it's a team or one person. And of course, are any of you using an outsourced HR team?
Okay, just a couple more seconds.
Yeah.
Okay, I'll close the poll and share those.
Lovely, thank you. And I suspect you almost know now that there's going to be it's going to be very busy for the next few years, as you'll also find out in this webinar. So a couple more, and that's really about your organisation. Are you unionised, first of all?
Nice simple one.
Yeah. Okay.
And I think I'll close that and share those.
Okay, so
yeah,
majority of you.
Majority not, but there definitely are some who are. So
yeah, so there'll be interesting points as we go through the slides. And then just finally, which sector do you operate in, public or private, or if you mixture of both?
I guess that's coming out as we would expect. I will close that poll and share those results. So there we go.
Okay, so most of you operate in the private sector.
But definitely some public sector ones here, and there's going to be more overlap, isn't there, coming up? So
there'll be some interesting reforms there that will affect everybody. So without further ado, I'm going to just provide that introduction to the Employment Rights Bill and just set the context. So as I hinted, the bill is significant. It's massive. It's got 28 reforms that cover the entire employment life cycle, which I'll summarise shortly. It's got the potential to become an act of law as early as the spring or even summer this year. Now, with some of the reforms coming in potentially not long after, although this is all, I guess, guesswork at this point, we just need to be mindful that as soon as the Act is passed, some of the reforms could come about straight away, but there's majority of them will be next year. When passed, it will be incorporated into the Employment Rights Act of '96, and as I said, for those of you who work in HR and probably know, it's expected to be the biggest shake-up of employment law in decades. The bill is still currently going through Parliament. It's in the House of Commons. It's going through amendments and the various debates, and then it will be going on to the House of Lords for similar processes and stages. Before then, as I said, there is potential for it to be passed as early as the spring. But let me take you through at high level what we can expect before we look into the detail about the pay implications. And just to remember that the things that I'm going to be going through today, many of them still need further regulations, and it's the regulations that give us the detail for how you implement it. So I'll do my best in providing the detail where we know it, but there'll be many that we're still waiting for. So I've broken down the reforms into areas of employment. So if we think about contracts of employment and working arrangements, there's going to be many. So we're going to see reforms made to the current flexible working law. In particular, that's about the decision making. So if there's going to be a refusal, then that refusal must be reasonable. At the moment, the only requirement or legal test is that it's got to conform to one of those statutory decline reasons. We're seeing changes to the zero-hour contracts. So for those industries that operate using zero-hour contracts, this is going to be massive because it's going to essentially, they say, ban exploitative zero-hour contracts. And we're going to look at introducing a right to guaranteed hours. Similarly, with zero-hour contracts, there'll be the piece around needing to give reasonable notice of shifts, cancellation of shifts, and payment where there's shifts cancelled. We're going to see reforms in respect to the sexual harassment duty. So that came about back in October about making reasonable steps. That duty is going to be broadened to include all reasonable steps. and there's going to be legislation around third-party harassment protections. Similarly, with sexual harassment, the public disclosures will also now include anything to do with sexual harassment allegations. We're going to see a ban on fire and rehire, so the practice where you go through trying to change somebody's contract of employment, but ultimately you then dismiss them and then re-engage them. That's firing and rehiring. And we're going to see a change to the unfair dismissal rules that allow any dismissal connected to the failing to agree a variation of contract to be unlawful. A massive reform in respect of working arrangements and contracts is the removal of the at-one establishment requirement for collective consultation purposes. And that's all about at what point you need to start collectively consulting. I'll come on to some of these in more detail as we talk about the pay impact of them. I'm not sure if there's any ship operators on this webinar, but there's going to be a requirement to notify the Secretary of State when there's collective redundancies. And that all came about because of the P&O redundancy chaos that happened a couple of years back. And then we're going to see the introduction of action plans for employers who employ over 250 employees. So all of these alone are massive, and we're going to, as I said, cover some of them in the pay section. There are then, when you think about pay and benefits, reforms, and most of these are what we're going to be covering. So we're going to see the removal of SSP waiting days. They're going to remove the lower earnings limit that's currently required to earn SSP. We're going to see changes in how the national minimum wage is managed, particularly from a removal of the age bands. Employers will need to, by law, consult with their employees when it comes to the tipping policy. So for those of you who operate in hospitality, then there's going to be some further changes in regards to that. And we're also going to see changes on the gender pay gap reporting. So it's more broadened to require employers to disclose employment agencies that supply them with workers. And if you didn't think that was enough, we also have reforms coming up in regards to family leave. So paternity leave currently has a 26-week service requirement to be able to take time off. It's now going to become a day one right, and employees will be able to take paternity leave after shared parental leave. We're going to see parental leave also become a day one right, and that's going to align all of the different various forms of family leave, so they all become a day one right. There's going to be the introduction of bereavement leave of at least 2 weeks for all workers. And as we saw changes last year with how redundancies are managed for somebody that's just returning from family leave, that's going to be broadened. So it's going to become unlawful to dismiss an employee on return from family leave, not just specifically in regards to the redundancies, but in all aspects of dismissals. And there is more. So when it comes to industrial relations, so we know that we've got some of you on here today working in the public sector who are unionised. These are some of the things then that you need to be mindful of. So if you do operate in schools, then we're going to see the school support staff negotiating body reintroduced. We've got a new adult social care negotiating body as well on the horizon. When it comes to trade unions, we're going to see some reforms to actually a lot of the trade union laws, repealing most of the measures that came in 2016. We're going to see reforms to the statutory recognition process, and essentially the rights and responsibilities of trade unions are going to be enhanced. So there's a lot going on there from an industrial relations. And then if we think about finally the enforcement of all of these employment reforms, there's going to be the establishment of a new enforcement body called the Fair Work Agency. So they will have statutory powers to enforce when employers are either not paying statutory sick pay or national minimum pay rates. So they're going to have a remit of the areas in which they can enforce employers to ensure they're compliant. A massive change, and probably the most significant, I would say, if you think about it all, is the unfair dismissal right. At the moment, you need to have 2 years service to be able to claim for unfair dismissal. That's going to be abolished. And so it's going to become an entitlement from day one of employment. And what that will look like and how it will mean we work in practice is unclear, because we need some further clarity through regulations and codes of practice, etc. But that is going to be significant. There may be many of you on this webinar that perhaps use short service dismissal approaches in situations, probation periods. You know, how does it operate in a line with somebody's probation period? And actually, we are looking at having a new statutory provision in place to make sure that everybody does have a probation period. And I think the government are thinking around 9 months. Another huge change will be around the tribunal time limits. At the moment, you need that 6 months. At the moment, an employee has 3 months in which to claim at tribunal, but that's going to be extended to 6 months after the incident or allegation that they're claiming for. So these are all significant, and that's why I said a few moments ago it's probably the biggest shake-up of employment law in decades. So we're going to be running some polls now, because it'll be interesting to sort of get your thoughts as well. So there is a lot planned. So if I can ask you to call up the first poll, and it's really, I know I've just given a quick high-level overview. Which of the following support mechanisms would be most helpful for your organisation in preparing for the reforms? And you can select as many as you feel.
Because we're aware the impact of these reforms is significant, so we're trying to target the support where it's needed. So hence it's really, really useful feedback for us.
Yeah.
So we know what to how we can help you.
And
okay,
also I was just going to say, it's about giving that helping hand, helping guide employees through it. So as the poll results show, so yeah, webinars and training is going to be massive, not just for your line managers, but actually your HR teams, your payroll teams. Yeah, absolutely. Further guidance and resources. And we feel the same, in that, you know, we are waiting on further guidance in terms of regulations, as I said, codes of practices. So thank you for that. And I guess, Sue, from your perspective, if you were to put yourself in the position of an employer, what's your initial view on the reforms like those that I've just set out here? And are there any reassurances you can give to anyone?
Well, I guess, I mean, as you've said, you know, not all of it is going to be introduced in one go, which thankfully, because that would be just impractical for everybody to implement. And the government do know this, they're fully aware of this. But for many of these changes, if not all of them really, we need the detail before we can really bottom out what we can provide and what we need to do. So they will publish regulations on each of these changes, and that's the bit that gives us the detail of what they're actually enacting, and then whether or not there needs a code of practice drawing up, or whether they're just going to give specific guidance. And that's what we need really to know how on earth we're going to manage all of this. Some of them could potentially come in this year. There's some that don't actually need regulation, aren't there? And so we could see later on this year 1 or 2 of them coming through. And we have indicated where we think there might be chance that they'll come in this year, although the majority is definitely next year, towards the autumn next year. So we will have time to plan. We're already planning ourselves as to what we might need to produce for all of this, so that once we know the detail, we can sort of launch it as soon as we can afterwards, to give you the maximum time to help you prepare. But yeah, I
Thank you.
Think, it's an exciting
busy time ahead. But like you said, there's that reassurance, isn't there, that it's, I guess, a staged approach to bringing them in.
Yeah. Okay.
Thank you.
Thank
So
you.
I'll move on, and actually on that, I've covered here on this slide. So if you think, I've just gone through so many different reforms, but actually, as Sue touched on there a moment ago, some could be ready to be implemented this year as soon as the bill becomes an act. And so I've highlighted here on this slide which ones have that potential. Now, for me, the things that I would say for you to sort of prioritise and focus on, I know that's all of them you need to, but the ones in particular would be around that ban on firing and rehiring and making the reason for dismissal connected to that variation unfair. For those of you that perhaps operate over various different sites, the whole at one establishment is a massive, massive change. And because it basically is around at what point do you need to collectively consult, and it's just going to have massive implications for employers. Sick pay, so it's not all going to be introduced in the one go. The first approach is about removing the waiting days to making it day one from the sickness absence. Tipping policy, as I said, those in hospitality, we're going to see some reforms there. The increase in timescales, I mean, that could come about instantly, pretty much, allowing people from 3 to 6 months to put tribunals in, and a Fair Work Agency. So you will, as I said at the start, get copies of all these slides, so don't worry, but this slide is reflecting what has the potential for 2025. So now moving on to the main section, and that's the actual implications from a pay perspective. And I guess I just want to consider both direct and indirect costs. So the obvious going from direct costs will be the increased employment costs, whether that's provisions for the national minimum wage, raising payroll expenses, changes to statutory sick pay, paternity leave being shifted forward, so everybody from day one. And then you've got all the indirect costs as well. So it's going to take an enormous amount of management time to navigate through these reforms. It'll need policy updates. Your HR teams dedicating significant time to updating their internal policies, contracts of employment. Managers need to go about implementing it, working with unions if you're unionised. It's thinking about the training for all your line managers, HR teams, payroll, budgeting and forecasting, of course. And then do you need new systems and working practices to support compliance with the reforms? So there is lots and lots of things to think about and consider. But if we take the reforms now, what I'm going to just show you is which ones have the potential, and I'm going to set out obviously what the reform is and then the implications. So from a genuine living wage perspective, the government want to deliver on that promise because they want to do that by removing the national minimum wage age bandings, because they want all adults to be entitled to the same minimum wage. The change criteria as well for determining the national minimum wage will or has already been expanded to include the cost of living. It never used to be, but from the autumn, the Low Pay Commission has put forward an element into the new national minimum wage rates. So I just wanted to also say the general living wage mustn't be confused with the term real living wage. The real living wage is that voluntary scheme that employers can sign up to if they wish to ensure workers receive that wage based on the cost of living. So for example, the minimum wage rate for 21-year-olds at the moment across the country is £11.44. The real living wage is actually £12.60, but if you're in London, £13.85. So the government want to make sure that everybody, as a statutory minimum, has a genuine living wage. So it'll be interesting how over time, what the real living wage, I guess, organisation, how it exists moving forward will be interesting. So in terms of the pay implications, then obviously what we're going to see is increased wage costs. You're going to have to budget and forecast, so you're going to have challenges around that. You need to factor in these rising wage costs when budgeting and forecasting. the changes make it more difficult to predict future wage bills because the link that we now have with cost of living makes the increases less predictable. It could have an impact on competitiveness. So businesses operating in sectors with tight margins or have a reliance on minimum wage employees, then obviously this could involve significant changes in the service delivery, or even the need to actually downsize. And there's going to be pressure on pay differentials as well. So as the minimum wage rises, employers may face pressure to increase wages for the higher skilled roles in their organisations so that they maintain that appropriate pay differentials. So that will have a knock-on effect, increasing wage costs across the board. So there are some implications to consider when we're talking about these statutory pay limits. When it comes to sick pay, we could see one part, as I said earlier, the reforms of this, and that's about removing the waiting days. That could be this year. They are also proposing to remove the lower earnings limit. So low paid workers will receive SSP either as a percentage of their earnings or the flat rate of 116.75, whichever is the lowest. The government have recently been consulting on that to get views from businesses, and so we're waiting the outcome of that. And then also another reform is that the non-compliance to the SSP rules will fall in scope of the newly created Fair Work Agency. So I think this is going to be one of the biggest reforms. We're going to see increased SSP costs because removing those waiting days means employers will be paying SSP from day one, as I've said, leading to an increase in overall SSP expenditure. Removing the lower earnings limit means also that employees who previously didn't qualify will now be qualified to receive it, increasing the number of employees receiving it and the associated costs. The proposed calculation method for low earners, so having that percentage or the flat rate, whichever is the lower, that's going to add complexity to payroll processes. So employers are going to need to ensure they've got the systems in place, processes in place to be able to correctly calculate and administer SSP for this group of employees. And of course, there is the impact of potentially seeing increased absences. So the changes might actually lead to that increase in short-term absences. Employers are now incentivised to take sick leave even for short periods, so that could again contribute to increased SSP costs and potentially impact productivity as well. And then when it comes to enforcement and penalties, the introduction of that Fair Work Agency means that non-compliance could lead to enforcement action and potential penalties for employers. So it's really important that the compliance you are fully compliant with the rules there. So for me, I think the statutory sick pay is going to really hit hard on organisations. If we think about tips and gratuities, and I appreciate that not everybody on this webinar will this will relate to, but for those of you that do operate in, say, hospitality, where it is common practice, there are going to be reforms to the law that came in at the end of last year, and that's about consultation with employee groups, representatives, before, first of all, producing your first version of your tipping policy. But then it's going to need to be reviewed no more than 3 years from when the previous policy was reviewed. And then, as part of that consultation process, there'll be a legal requirement to publish an anonymised summary of those views expressed. So of course this is going to have implications from a pay point of view, because well, first of all, by making it a statutory requirement to consult as opposed to best practice, it's just, I guess, opening it up for more potential disputes, and therefore there could also be associated costs, because depending on the relationship you have with the working parties or unions, then essentially you could be exposed to changing how you allocate the tips. So on the one hand, the policy is about transparency and fairness. So if you have a poorly handled consultation process, you could see disputes arising from that. A poorly implemented policy or consultation can ultimately damage morale, leading to higher staff turnover. So there's many indirect costs really as a result of this. I think the big piece for me is around the fact that you have to consult. There's more likely that there's going to be challenge and proposals put forward to how you allocate the tips, and that's where the direct pay implications can be. We then have reforms to a couple of areas of family leave, and that's the parental and paternity leave. So first of all, we're going to remove the 26 weeks qualifying service needed to take paternity leave, and also it can be taken after the shared parental leave. At the moment, you're not allowed to tag it on to the end of the shared parental leave. And then we're also going to see the removal of the 1 year qualifying service to take parental leave. So this again is going to have the implications. We're going to see an increased SPP outlay. So you're automatically opening it up to more people to be eligible. And you're going to see potential increase in parental leave outlay as well. Whilst that's unpaid, some employers already perhaps offer it as paid. So it's how does this legal change interact with your existing policies? It's then thinking about the cover during those absences, because you've got more scope for more people taking the time off during the year, and it's the knock-on effect with resources and the administrative costs associated to managing your employment records as well and processing the SPP, for example. The bereavement leave is an interesting one in that most organisations already have some form of compassionate leave that they offer because it's just the thing to do. You know, when an employee suffers a bereavement in the family, it's just a natural response, isn't it, for an employer to allow them an appropriate amount of time off. Obviously, how much time off very much depends on organisation, the nature of the relationship, etc., of the employee with that person that's passed away. But what this reform will do is introduce a new 2-week minimum statutory bereavement leave. So I think for organisations, because many already have existing compassionate leave policies in place, it's trying to understand how that new statutory requirement operates alongside your existing policies. So you'll have that new illegal obligation to provide the leave, and therefore potentially leading to increased costs and administrative burdens. You've got that time out of the workplace, so it's about how you manage resource cover during those periods, because actually 2 weeks is probably not the usual, if you like, for the majority of when people need to take time out, compassionate leave. So it's going to have lots of implications here. So I would just say start thinking about your current policy and what it will mean by having to introduce a statutory 2-week. It might be that you continue paying paid statutory bereavement leave for so long, and then the remaining time is unpaid. We need more details. This is again one that's going to be from next year onwards, so we are waiting the regulations and then we can give more clarity. Now, 0-hour contracts, we have many clients that operate these because of the amazing flexibility that they can offer. So the reforms that we're looking at include offering, basically they're removing the I guess the type of contract where exploitative is the phrase, and what it's going to do is there'll be a requirement to offer qualifying workers a guaranteed set of hours that reflect the hours they have worked during a defined period. So whereas just at the moment you have that contract in place, there's no hours set within it, but you have that working relationship where you have that flexibility and you can call upon that person. That will be no more. Instead, somebody will need to have a qualified number of hours in their guaranteed number of hours in their contract. They will also have the ability to bring an employment tribunal claim when shifts are scheduled or changed without reasonable notice, and if shifts are cancelled, moved or curtailed, then shifts at short notice, then they will require pay. So this for me is a massive area, not from just a cost point of view, but from actually how you operate, how you rely on that flexibility from your 0-hour contract. Because what we're going to be doing now is we're moving to a position where you're going to get increased wage costs, especially, like I say, those businesses that have fluctuating workloads or seasonal staff. Because when it comes to budgeting and forecasting, your ability to predict labour costs will be more complex, because you're going to need to factor in the guaranteed hours obligation, regardless of the actual output or demand. So you're going to have to employ somebody for those guaranteed hours, even if the work is not there. So if employers are required to guarantee those hours based on a previous reference period, like I said, they're going to be obligated to pay more for hours than they currently need, leading to those budgeting and forecasting challenges. The changes may force employers to rethink their employment models and obviously move away from relying heavily on 0-hour contracts, impacting flexibility. And so instead of opting for having a workforce operating in this way, employers are going to be needing to opt for more traditional employment contracts with fixed hours. And the knock-on effect from that, I would say, is would it trigger off conversations about needing to restructure and then potentially incurring costs associated with doing that and redundancies or the hiring. Employers are also going to need to track workers' hours carefully over the reference period to determine the appropriate guaranteed hours. Now, there is talk that the reference period is looking over a 12-week period. But it's going to mean you're going to have that administrative burden of keeping accurate records and calculate the guaranteed hours for each qualifying worker. And it may also open up the door for negotiations with workers or unions regarding actually what is the appropriate level of guaranteed hours. So it may be that you start having more disputes, and it just overall brings complexity. And when it comes to redundancy, I sort of mentioned early on that actually this removal of the at-one establishment is actually significant. And the at-one establishment is a test for the purpose of when should you be collectively consulting. So currently under the Trade Union Labour Relations Act, employers have that legal obligation to inform and collectively consult when it proposes to dismiss on the grounds of redundancy 20 or more employees at one establishment. So we've had lots of case rulings back and forth, and it's never clear cut, and it is always very much fact specific. But the point that we're at the moment is that I think UK law has established that the one establishment is a unit or entity where the workers who are made redundant are assigned for the purpose of carrying out their duties. Now, that is a vague sort of position. The facts of the case would very much depend on it, but that's where we're at. But what the Employment Rights Bill is proposing is to remove references to one establishment so that the requirements to collectively consult and to notify the Secretary of State will apply across its entire business. So I think that's going to be a massive shake-up, as you know, for those organisations that do have more than one site. We're already seeing lots of queries, questions coming through to us around restructuring, redundancy, just because that's the, I guess, the economic climate at the moment. So I think it is going to be significant, and it is one that could come into force relatively quickly once the bill becomes an act. So from a pay implications, what we need to think about is, because at the moment, employers who fail to properly consult with employee representatives, they can be ordered to pay a protective award to those affected employees. It can be up to 90 days pay. And so by removing that one establishment test, more redundancy situations will trigger the collective consultation requirements. And therefore, if you're not complying, you could see yourselves being taken to tribunal with claims of for those protective awards. The need to consult with representatives across multiple sites can also make the redundancy process more complex and time-consuming. Those delays can lead to increased costs, especially if those employees continue to accrue, wages during the consultation period. So there is a lot of implications from this point of view, and of course the administrative burden and those related costs. So how do you consult with representatives from multiple locations? That all adds on to the administrative side of managing redundancy. Do you need to invest in new systems or dedicate more staff to managing the consultation process more effectively? So there are a few things that we need to be mindful about, and when we think about planning for the future. Now, I know there's a few of you on here who operate in the public sector, so I'm just going to run through relevant reforms specific to that. So we're going to see the creation of the adult social care negotiating body. We're going to see the introduction of fair pay agreements in adult social care. For those that work in education, then the reinstatement of the school support staff negotiating body, the SSSMB. And then we're also going to see a duty imposed to ensure that transferring workers who were originally employed by public sector and moved to private contractors are treated no less favourably, and vice versa. So that's basically trying to get rid of this two-tier workforce. So what this will do from a pay point of view is clearly it's going to increase labour costs. You're going to obviously, through having to introduce fair pay agreements, we can expect to lead to higher minimum pay rates for care workers. The fair pay agreement and the school support staff negotiating body are likely to establish normal national minimum standards for pay and working conditions. And then, of course, by removing that two-tier workforce, for those in terms of transferring, TUPE transfers, there's got to be that equal terms of employment for everybody. So there are some big implications there, especially if you're operating in an organisation where TUPE is quite a common practice. When it comes to trade unions, so again, some of you are unionised, then we're going to see the right to paid time off for trade union equality representatives, and there's going to be reforms to the statutory union recognition process. So in terms of direct costs, what we'll have here is obviously you're going to need to pay employees for the time they spend on those trade union equality duties. That could be such as attending training, meeting with members, negotiating on equality related issues. From an indirect cost, there may be those associated with covering the workload of the employee when they're on that form of leave, and it may be that you need to use overtime pay for other employees. The reform of the statutory union recognition procedure, I think, is actually quite significant because it's going to make it easier for unions to gain recognition. And once you've got that recognition, yes, there's a lot of benefits to working with unions from an employee morale, engagement point of view, and fairness, etc. But actually, with the potential increase for recognition requests, once you are unionised, then it's about that relationship, managing that relationship, and actually being exposed to the risk of challenged on how you pay and reward your employees. And so costs may naturally just incur because you've got that formal and union membership and bargaining power. So the exact pay implications will depend on the specific details of legislation changes related to these issues. So it's really important to stay informed and up to date. And then if we think about the enforcement, so the Fair Work Agency is going to be introduced. That has a potential for this year, along with the extended time limits for tribunal claims from 3 to 6 months, failing to agree a variation of contract to be unlawful. But I say if there's any good news, then the good news is about the unfair dismissal day one right. It's going to be a long way off. they're saying not before autumn 2026, and alongside that the statutory probation period. So we do have that time to be thinking about it, how it'll operate, how it will work within our own businesses. So the last two bullet points there are not until autumn, at least autumn 2026. The others, though, could in theory come in place this year. So in terms of pay implications, so while if we think about the Fair Work Agency, in itself doesn't directly dictate pay rates, its enforcement powers will likely lead to increased scrutiny of pay practices. The agency's presence may encourage more employees to raise concerns about pay and working conditions, and therefore you may lead to having more disputes, claims, etc. As a result. When it comes to increasing the time limits from 3 to 6 months for raising a tribunal, this extended time limit significantly increases the period during which employers are potentially liable for past actions. It could lead to higher settlement costs or legal fees if claims are brought for events that occurred further in the past. And when we think about the unfair dismissal day one right, this is going to significantly increase the potential for claims, obviously, and therefore it could be that you see higher legal costs in trying to defend and respond, and in theory, potential compensation payouts. And from an indirect cost point of view, employers need to ensure they have robust and fair procedures for managing performance issues, dismissals, etc., even for new employees. So I sort of mentioned earlier around some organisations have approaches where, because they know the individual has less than the 2 years, they've got slicker processes in terms of how they manage any short service dismissals. That's going to have to be rethought, and how you operate is going to be massively different. And statutory probation periods, whilst at the moment probation periods are best practice, we always advocate for them. They're a good opportunity to for both parties to see how that new employment is for them. And some organisations don't operate them, but the reforms will require it alongside obviously bringing the day one right for unfair dismissal claims. So that's going to be bringing cost implications in terms of the administrative side of introducing probation processes, but also the training costs. If employees require significant training during that extended probation period, then naturally that's incurring costs. So before we take some polls on all of what I've just sort of shared and my thoughts, I'm just going to sort of summarize where I think what I think would help. So first of all, the really important thing is to stay informed, because if you don't, then you're going to be left behind, and that's where there perhaps could be risks, exposure to risks. So stay informed of what's happening, what is due to come in and when. A really important tool will be about impacting the impact assessment to see how the reforms impact your organisation. You're going to need to review existing policies. You're going to need to establish consultation mechanisms to be prepared for these reforms I've mentioned. You're going to have to look at how you standardise your consultation paperwork, record keeping methods, and look at potential triggers for collective consultation. And when it comes to consultation, it's about engaging in consultation early. Many of you will need to carry out workforce modelling and resource planning, particularly in regards to if you're reliant on 0-hour contracts and need that flexibility, but also just from the pay implications, it's going to get you thinking about your organisation and if it's operating as the way it should once reforms come in from a cost point of view. You're going to need to review how you operate shifts and rotas in terms of the notification timeframes and things like that. Review your HR payroll systems, explore productivity improvements to help mitigate against the costs associated, but also plan for future cost increases, because we know there will be additional costs, but actually what's to say, there could be further increases coming our way. And really importantly, it's about updating your key employment documents. So that's your contract of employment, your policies, your procedures, and your handbooks. And ultimately, it's not good just to have all of these unless you've got your line managers trained, knowing how to apply the law in a practicable way. So it's about training your line managers and your HR and payroll teams. Now, I'm going to just run some polls, because I think it's really interesting to see how other organisations are feeling about these reforms, and it will help just everybody on this webinar now. So, and it will also give my voice a rest. So let's see what the first poll is, and that's about the what you think the biggest impact is going to be.
Okay, I will just leave that for one more second.
They're probably equal, aren't they?
Yeah.
They're so far reaching.
And yeah, absolutely. And I think, well, we'll come on to the questions in a minute, but it's, yeah,
Okay.
there is a lot of, as we all are, a lot of interest here. So I'm going to close that poll and share those results. Yeah, the biggest burden is definitely going to be the increased costs. We're finding that already. There's a significant increase in the number of clients who are having to look at restructuring, redundancies, and rethinking, adding passing costs on and things like that. So yeah, it's really, really tough time out there.
Okay. Yeah, and actually the maintaining competitiveness, that's 20%. Yeah, so it's got far-reaching implications. Okay, and the second question, we've got a second poll.
Yeah, I'll just load the next one, which is, which one do you think are going to have the biggest impact on your organisation's pay practices? So the focus today is on pay, the implications of pay. Bearing in mind how much we've talked about today, and that's just the implications on pay. And there's a whole load of things we haven't yet covered, and they'll have their own sort of individual webinars during the course of the year when we know a little bit more information about them. We've tried to time them around when we think we might know more, because that's the hard thing about today, is that there's still so much detail that we don't know. But yeah.
So yeah, so let's.
Okay, should we close that
See
one?
How everybody's feeling, what their thoughts are. So yeah, statutory sick pay.
Yeah,
that's the biggie.
It is.
And I think the removal of the age bands is probably that many of you here aren't necessarily operating at the minimum levels anyway. So there's already that scope. You're already accommodating higher pay rates. 27% for the 0 hours. Yeah. But yeah, definitely sick pay. And just, like I keep saying, it could be one for this year, which would be interesting. Okay. And then I think a third, final one in this section before I move on. And I'm conscious of time, but please do stay with us if you can. We've got a few more slides. But yeah, if you can, that'd be great, because we'll go through to the end.
We've got one more after this, I think.
Yeah.
This is kind of exploring a bit deeper what the challenges are, and then we'll look at what you're doing currently. I say all of this is really, really interesting. It helps inform us as to what we can provide in future topics, where to focus our attention, and also you know, providing you with the resources that you actually need. So it helps us to understand our audience. I'm going to close that poll and share those results. So here we go. So the biggest one is the budgeting. And then communicating it and complying.
Compliance. Which is,
that's hard.
I think if you haven't already started following the developments and keeping an eye out, now's the time.
Okay. So if I hide that, I think.
Yeah, there's one more, I think.
Mitigation.
Yeah. So
if I launch that poll, there we go. What are you looking at the moment, or what are you considering to help to mitigate some of these the pay impacts of this bill.
It's really difficult, isn't it?
Mm.
How you juggle it all.
I think the good news for everybody is if you stay close to us, Victoria's key job is knowledge. And that's making sure that the team here, as well as all our clients, are kept informed about all these changes. So we have a lot of plans ourselves at how we keep everybody informed in terms of information that we're going to make available to you via our website and via emails, newsletters, things like that, that we can keep you up to date on what's happening and when, what you need to do. So I'm going to close that one and share this one. So there we go.
Okay, yeah. So cost saving measures and reviewing existing pay structures.
Mm.
Yeah, that's definitely the priority, I think, isn't it?
Yeah. Okay,
Yeah.
I will
Lovely,
hide
thank
that one
you.
there for you. There you go.
Lovely. Because what I'm going to do now is just sort of take you through how we feel that we can prepare for change, and we've got a 10-point plan. So like I've said, stay informed, understand the reforms, because from there you can determine what steps you need to take for your business. And as part of doing that, it's about assessing the impact of it. So how will each of those reforms that I've gone through today impact your business? They're going to impact businesses in different ways. So carrying out that impact assessment is going to be vital. The budgeting and forecasting, as we've covered, is essential. But also think about your employee value proposition. So how can you remain competitive as an employer? Because if you don't quite get the right pay and reward strategy as a result of your planning, but then your competitors seem to be doing something different, that actually you're finding it difficult to recruit or even to retain, then it's about just that's your EVP. So make sure that you're reviewing your employee value proposition so you can maintain that competitiveness. Carry out that comprehensive workplace audit. So what does your workplace look now in terms of your policies and procedures, and what does it need to look like under the new reforms? It's about developing compliant policies and working practices, and actually it's probably worth starting now to think about it, and engaging with your unions if you're unionised. And that's why I said here, engage and consult with your workforce, because it's about taking your workforce with you and keep them engaged. We are going to see reforms to trade unions. We do risk as well seeing an increase in union recognition requests. So really think about, if you're already unionised, your existing relationship, but actually if you do get requests for recognition, think about the kind of working relationship you want to achieve. Training your workforce is going to be fundamental. And as I've said several times, it's not just about your line managers or your employees, but it's also your HR teams and payroll. And if you think about, especially industrial relations and trade unions, it might not be a common area for HR professionals to have got experience in, but potentially it could become an area that is growing. And so it's about training your HR teams, even on industrial relations and union recognition and all of that stuff. And then consider the wider pay implications. So what's the knock-on effect with your reward strategy, your retention strategy, your recruitment approach to recruitment? It's looking at the entire employee life cycle. And I've mentioned a couple of times about a HR risk audit, so I want to just explain a little bit more than that. So it's about having that comprehensive audit that's that key step in preparing for the Employment Rights Bill and the reforms. It's about helping you to identify gaps, assess financial impact, and prepare for the implementation. And so taking that proactive approach, you can ensure that smooth transition and maintain a compliant workplace. So it's really going to be an essential step. We do offer a free risk audit ourselves, and our audit is designed to ask you questions about your business so that it enables you to identify those risks to you as a business, and more importantly, to provide you with guidance and support on how to de-risk these. So currently it's giving you a good understanding now of how you operate in the context of employment legislation as it is now, which if you are in a good position with compliance, it means you can just focus on those reforms as we get nearer to them. And then as we get nearer to the reforms being introduced, our audit will then be available to you that's specific to those reforms. The questionnaire takes about 10 to 15 minutes to complete. Once completed, then you get your own personalised report, summarising your responses and giving you some recommendations. So this is a good opportunity to take part in doing your own HR audit now, making sure you're squeaky clean now, ready for the reforms coming up. And then I also mentioned about a key activity being the impact assessment. You know, how will the reforms impact your business, particularly those that I've gone through today? So that impact assessment will allow you to assess those parts of the reforms and how they will impact you, so you can get that better understanding of potential cost implications, changes that need to be made from a payroll budgeting and pricing strategies. So by understanding the impact of the reforms early on, you can then make those informed decisions about how to absorb or mitigate those costs. So we're going to be launching at our employment law seminar in March our own impact assessment tool that will become available. So, and using that tool will then be able to help you develop your own strategic people plan and to help you map out what you need to do to remain legally compliant. So do come along to our virtual employment law seminar, because it'll be a great way of accessing our tools. If you do want to get in touch with us, then please do. You've got the email address for me there. Our website is obviously noted there, as well as the phone number, and you can also follow us on LinkedIn. Business HR Solutions, or myself and Sue are also on LinkedIn as well, so do give us a follow. So now we're at the questions, and I am conscious it is just a little bit past 11. We will take a few if that's okay, Sue. But as I said at the outset, we will provide a written FAQ as well. So if we can't get through them all, then we will be following up.
I have to say, thank you for your questions. There have been a significant number of questions. And okay. just to generalise slightly, the majority of them are, as we all are, needing to know the detail before we can really respond. So as we've promised, we will come back to all of the questions that have come through. There's some really interesting concern around, for example, bereavement leave. You know, are they going to change the scope of the family that's covered by bereavement leave? You know, is it going to be just immediate family, or is it wider? Are they going to touch that, or is it literally just minimum 2 weeks, and it's up to the employer to determine the scope of that? Yeah. As we got at the moment, complete discretion on it. I'm not sure. We're not sure, but so quite a few questions around that. There's also a lot of questions, as you would expect, around the working time. The 0 hours contracts. And I think this will raise the question again, and probably something we need to look at is ensuring that actually the staff are on the right contract, because where one example that was given was that they had somebody who worked 1 year in August, and then the following year probably not till February again. That probably isn't a 0 hour contract. That's probably a casual contract where it's really ad hoc work, and therefore it probably wouldn't be covered in the same way of the scope of the 0 hours, where you're offering a more regular work but no guarantee of hours. And then there's also the 0 hours contracts, whereby it's a permanent contract, but it's a flexible number of hours each week depending on the work that comes in, which is another contract altogether. So I think there's a whole host of stuff that we need to review once we know the detail and the scope of all the regs, the detail of the regs and any codes that are going to be brought in. So there's quite a few questions around 0 hours, say bereavement, flexible working, the probation period, which, as we anticipate, is a major thing. Making a probation period compulsory is, I've never known that in my working
No.
life. So that's quite a significant change, and will have a lot of impact on how we manage new staff, especially those that are not working out, what we actually do with them. We have the concept of a short service dismissal at the moment. That's going to be quite different in the new world. So yeah.
Lots.
A couple of the questions that we had prior to today in the advanced questions were around SSP, and I think yes, it is going to be quite significant SSP from day one. If you don't currently pay sick pay, or if somebody's on variable hours and rotas, and you take someone on for a shift and they call in sick the next time they're scheduled on, do you have to pay them sick pay? Well, most likely yes, but it depends on the other qualification for the rules as well. So, but yeah, potentially. But again, it's all going to be in the detail once we know it, I think.
Yeah, and what I'll do then on the questions, if I sort of group them into the categories and then provide responses, and then just be assuring everybody that we're incorporating all of your questions.
Yeah.
But yes, interesting.
Yeah, absolutely, really, really interesting. And thank you for your lovely feedback as well that we've been receiving through the questions.
Oh, that's good.
Yeah.
So I'm just going to run a couple of quick polls, and that's really about, first of all, how prepared do you feel your organisation is for the potential pay implications of this bill?
Okay.
Yep.
I will close the poll and share those results.
Okay.
Yeah.
Okay.
But
and I think
there's quite a few that are neutral, which is good, because I guess now there's an awareness, and we're trying to increase that awareness. Then you can start to think about it. So, and attending today is a start, isn't it, for some people of starting to think about the impact and what they need to do.
And it's good with, so now we're talking about it now, and we've still got some way to go, which, if you haven't started, don't panic. Now, like Sue said, you've, joined our webinar, you've got all the information, and it's just now taking the next steps and thinking about it and the impact on your organisation and what you can do. And then we've got a second poll as well. So that's more about what further information or support would you like to receive from us, for us getting in touch regarding the bill and its pay implications.
So this is if you want us to come to you directly, isn't it? Specifically at this stage, as opposed to what we've been collecting throughout, is what collateral we need to work on to provide you with. But we can help with all of it if you need help. And we work with a huge number of HR teams as well, just giving them an extra resource, and a sounding board sometimes, and a sympathy call sometimes. Help them through a challenging...
We're all in it together.
time.
We'll all be tearing our hair out together. But even just, as a soundboard and just running thoughts past each other, and talking it through.
Okay, I've closed that now.
Brilliant. Thank you.
Thanks.
So just a few more slides. Just first of all, our HR knowledge base. Some of you may be subscribers and members of the knowledge base, but for those of you that aren't, it's an online HR resource. So it essentially provides you with template HR documents and policies, as well as a library of articles and guides to keep you fully informed, and HR guidance. So that's a product that we offer. As I said, some of you may already be using it and subscribe to it, but if you want to find out more, there's a QR code and a link there as well. I mentioned webinars, so we have a lot planned for the next 12 months, as you'll see on this slide. So most of them are all geared around these reforms. We do have a specific one on actually calculating annual leave and entitlement, which we had all that last year, if you remember, with the rule changes. That's not necessarily part of the reforms, but because it's such a topical topic, we're actually dedicating a webinar next month. We've obviously got our virtual employment law seminar. And then, as you see, we've got specific topics covered. So the redundancy, so it's about preventing the process and the key steps for ensuring it goes smoothly. We are going to be talking about statutory sick pay in May and 0-hour contracts in June. And then towards the latter part of the year, we're going to be looking at how you manage family-friendly leave and prepare for those more flexible working requests. The importance of probation periods and how they may change is going to be a biggie. Hopefully we'll have some more clarity at that point, even if it might be in draft format. And then we're going to look at discrimination later on in the year, and actually in October is going to be looking at protecting the business from tribunal claims. So do please register, follow us, join our webinars, sign up to our newsletters. It'd be great to have you follow us and join us on this journey. And then, as I said, here's the reminder for the virtual employment law seminar, so it's free to register. We're going to go through the bill and obviously additional changes, because we actually have neonatal leave and pay coming up. That has been confirmed. So we're going to give you more details on that, along with some other rulings. So there's a QR code, and hope you can get to join us. But I just want to say thank you to everybody for joining today, and apologies that we have overrun. I hope you understand it's not the easiest or straightforward of topics to cover. There's so much to it. Thank you for all the questions, and Sue for your support as well. And we will follow up with the relevant information we've mentioned already after the event. So thank you, and enjoy the rest of your day. Thank you, everyone.
Thank you.